From the Library of Congress in Washington, D.C.
So next, I think I'd like briefly the panelists to state their name and any affiliation or interest they have with the category, and then we'll start with some presentations. So Mr. Chatfield, if you could introduce yourself.
Thank you. It's always great to be back in the district, especially at these times. My name is Keith Chatfield. I'm founder and CEO of Solobyte Corporation. It's a company that was founded really to help the consumer actually enable their capability to create libraries of content legally. We have technology we've developed and working prototypes of a system that can actually create, and we'll show you that here in a little bit.
Right now, we just need the name and introduction, just because we are time limited.
Okay,
so you will certainly get the opportunity.
I need a
to
protocol
make that
droid here, so sorry.
Yeah, thank you.
So I'm John Mitchell, an attorney representing OmniQ, of which I'm actually a partner. Normally I represent retailers since 1988 of movies, videos, and so forth, but now I'm sort of wearing the hat of entrepreneur for the first time.
Matt Williams from Mitchell, Silverberg, and Knupp. I'm representing AAP, ESA, MPAA, and RIAA.
Bruce Turnbull, counsel to AACS LA LLC.
David Taylor, counsel for the DVD Copy Control Association.
Okay, great. So we have two brief presentations, and we're going to start with Solobyte, which we are calling Exhibit 3A, and then OmniQ's will be 3B. And so if you would like to walk up there, you can walk us through your presentation. This class is Class 3 about space shifting. And if you could try to focus on the areas relevant to the exemption, I don't know if there's additional material in it, and try to keep it to a few minutes. That would be great. Okay. Because the focus will be, yep. Thank you.
Let me see if I can, all right. So thank you for having me. I'll move through this as quickly as possible, and like you say, try to make it stick to the areas of that were under consideration. So just Solobyte, very, very briefly, we are electronic new media solution developers, and we have actually licensed. We actually have a method for space shifting, or actually moving content based on licensed transactions, not moving the files. We're here to support OmniQ in their proposal because there's a lot of good in that, we believe, from the consumer. Ability to convert content from weak security to more robust forms of security. We believe that companies that promote interoperability across devices and appliances and things like that is forward-thinking and actually expected technology or functionality for this digital age, and companies that future-proof content so that they're less vulnerable to platform app obsolescence is an important interest of the public. We mentioned this technology that we've developed. It's available. You can view it on YouTube, a demonstration of it. What it does actually is we've developed the only capability, along with partners, for a digital watermark to be inserted into a read-only media, optical media. So this is DVD or Blu-ray. We use this by adjusting, using firmware within an optical disc drive. So the drive that you pop your disc into to establish a digital watermark into it. This technology uses the laser and special firmware and tracking software to actually locate this digital watermark, so it can be actually placed in a specific location. It can also be used to disable the drive, or actually disable the disk in the field. So these create the capability to enable a controlled licensing transaction where you can trade in disk, disable disk, and register licenses and move licenses without moving content.
Can I ask you a question? Is this
Yes.
something you're currently offering in the market?
We have this technology now at basically through patents, and now we're offering it for licensing, yes, in the marketplace.
Does it involve circumvention of TPMs?
No,
Okay, go on.
no, you'll see. So just an example, a use case example of how this can be used. So let's say a consumer wants to move their content to new media. The consumer would scan their disk and authenticate, and during this process it authenticates the media and the content as being genuine, so it's not a copied disk. Once that's been confirmed by software, the content on the disk is identified, and a license is registered in a consumer's, or actually the owner's account. So they indicate they have this genuine article of content they purchased. The laser then renders the disk inoperable. So basically, they've just destroyed the disk by using the laser. This is the laser in the optical disk drive.
So, sorry, if you've destroyed the disk, where does the content reside now? On a hard disk?
The content doesn't reside anywhere, just a license record exists.
A license record? Okay.
So a license record is established in the cloud. Now, if the consumer wants to actually enable content to stream from the cloud or from new media, that license record now through a transaction will allow them access to a master in the cloud. So in this method, there are already existing, we know there are already existing masters of this content in electronic digital form available and already produced. This assumes that there's replacement content available on a server that they can then now access because they've registered their ownership and they've forfeited their original content and just replace it with new.
In your authentication process, there's no way to know if I bought a DVD and then passed it to all of my friends, correct? How are you verifying whether it is not copied?
We authenticate the disk originally to ensure that it's a genuine article through examination of the properties of the media. So we run through a process initially to determine that content is actually, or that disk is a genuine SKU, basically purchased item.
It's not tied to a transaction with a consumer or anything like that?
No.
Okay.
No,
Great.
it hasn't, we didn't take it to the extent of trying to, it's very cumbersome to the consumer to come up with receipts of, they bought this disc or whatever. So basically the disc is owned by an individual. Now what it can do, this process can take a disc that is owned and it's been confirmed that it's a genuine article and they in possession of someone and then actually then render it not usable. There is also another use of the use case that for time I didn't talk about, which is basically more like disc to digital, if you're familiar with that.
Okay, maybe if you can continue and get to how it relates to the prohibition on circumvention.
Okay. So what we believe is, first, we would like to use this technology to enable a recycling and archiving service that takes consumers, we estimate overall 13 billion of these discs are floating around overall worldwide. And we would like, this whole platform is actually sunsetting. It's getting old in the marketplace and being replaced. So a lot of these discs are going to be aimed at the landfill eventually. We like to actually pull those off, provide the consumer, register their licenses, and allow the consumer to archive these discs or their content into a more permanent library. So that's what we ask. We would like to see how this is used. With respect to, I guess, to make this short, what we are trying to do here is we support OmniQ because basically they're accomplishing very similar means with another type of technology, which we believe there are ways to use technology here for the benefit of the public and the consumer to keep law-abiding American citizens have the ability to continue to use their content in the future with an archive.
All right, thank you.
You're welcome.
And now I think Mr. Mitchell, yours is getting queued up right now, and this will be Exhibit 3B. Again, if you can stick to a few minutes, and then we'll dig in on some questions.
Yes, good morning. It's a pleasure to be able to talk about this. As some of the comments have suggested, we've been talking about it for a very long time, and we don't have it at market yet. But we put in a lot of pages, a lot of words, but I thought I'd just run through a few illustrations to try to put a picture behind some of those words. So we've the group was working with a number of veterans from the video industry as how the idea started, just realizing that as video stores are disappearing, the benefits of the first sale doctrine were disappearing. A number of efforts have been made to come up with a quote-unquote digital first sale, but they always involve something that's infringing of one of the Section 106 rights, even as they try to mimic the first sale. So what we came up with was a way to try to restore the benefits of the first sale doctrine, allowing, one of the critical points, allowing unlicensed redistribution. One of the problems, as we pointed out, is that whenever you insist that the copyright owner has to give permission for any transaction, it immediately presents those opportunities to price things according to how what benefits the copyright owner as opposed to the public, in contrast to the secondary markets that have flourished in the video era. So what we do is, there are three components, I guess, to this. One is from a DVD, and the reason we're here is the DVD portion, is the ingestion process of a DVD. We take a DVD and as we're moving the content to the hard drive, we're simultaneously destroying the DVD. And we do this in a rapid fashion so that we comply with the terms of the Copyright Act itself and make sure that there are never two copies in existence at the same time. Once it's on the hard drive, then we can transfer that in an encrypted format to a consumer with only one encryption key that we do not get to control. So once the consumer has it, there is no way we can recover that or see it, or it doesn't meet the definition of copy or fixation under the Copyright Act. To restore the data on our server, someone would have to return it. There's no obligation to return it unless it's a contractual one, but the consumer could have that on their hard drive until the hard drive dies. But if the consumer returns it under one of the business models, then they no longer have access. They cannot view it, reproduce it, or perceive it. And if the key is never returned, it's just like a broken disc in the mail. If Netflix, somebody stepped on the Netflix envelope before it reached your door.
Developed your own encryption technologies, or are you using a commercially available, encryption keying system, or what system are you using? Using
commercially available. Our engineer has insisted you don't need it anymore.
What is it called?
Well, I don't know what it's called, but from an engineering perspective, it's simply encryption that's hard enough. We encrypt every packet as it's being, or chunk, as we call it. So each chunk is encrypted. Do you
know of other products that use the same encryption technology?
My understanding is that this is essentially off-the-shelf encryption technology that's widely available. It's sort of a matter of how strong do you want to make it in terms of the number of bits and so forth. In our case, we have essentially two layers that very much ensure from an engineering standpoint that by the time you were able to break it, the copyright would have expired. So it's we're locked out. There's no back door. That sort of thing. So this slide simply summarizes that we simultaneously move it from one to another. And one key difference here is avoiding infringement of any Section 106 rights by non-reproductive space shifting. Nothing is performed publicly, nothing is reproduced. And here's where we distinguish ourselves from some of the other efforts that have been that have been tried. Zadiva had tried to have the equivalent of, you don't have, they would keep their disc and they would let you watch your disc from their DVD player, and the court said, no, that's a public performance. So everything was fine in terms of, it was fine for someone else to have your disc, but once they streamed it to you, that was a public performance. With Redigi, their patent itself said, step one, we make a copy. And step two was we go about deleting all the other copies. So the court basically said, no, step one, you already infringed. So even if at the end of the process you still have only one copy, to get to that process you had more than one. So in our case, we essentially stick within the Copyright Office, the Copyright Act, the terms of fixation, and make sure that essentially there is only one fixation at any particular time. We believe it really fits with a good future-proofing of the benefits of the first sale doctrine. It's more secure than a DVD. Once it's in our system, you can't just download one of the thousands of rippers and rip your DVD and make copies. No matter whether it was rented or sold, those can be done, but not with OmniQ. We believe it does reduce piracy by having this more readily accessible. And when we were fighting piracy back in the 80s, video rental was so cheap that piracy was not as big a problem as it was originally with the music industry, for example, at a time when CDs would cost as much as movies. Importantly, we restore that relationship between the copyright owner and the copy owner and protect the benefits that Congress had intended to enact back in 1909 with the first sale doctrine. And again, the permissions-based system essentially ignores a huge segment of our economy that cannot afford to have the broadband, multiple subscriptions to Netflix, Hulu, and everything else, or to pay full price for every copy that they are able to privately perform. So it's not a first sale doctrine issue, but we've tried to rest on the same principles as the first sale doctrine. Maintaining that right of the owner to be able to redistribute, and I won't go into further detail because it's in our pleadings, but essentially that's the magic.
Okay, thank you very much. I think as we did yesterday, we're going to try to divide the questioning into different thematic areas or buckets. And I think the first one maybe is to keep you on the hot seat, Mr. Mitchell, and ask some questions about the presentation you just gave.
Yes, Mr. Mitchell. So from the presentation, from your comments, and from the patent application you provide with your comments, I just want to make sure we understand the technology. And I understand some of these processes may take a very short amount of time. We could be talking milliseconds, nanoseconds, whatever, but I just want to make sure that this is the right train of events, that basically a small segment of the disk is encrypted and then copied into volatile memory. And I just mean copied generally. I don't want to talk about transitory duration or anything right now.
Okay.
But it's encrypted, it's copied into volatile memory, then the segment of the disk is destroyed. Then the data in volatile memory is copied into non-volatile memory, and the data stored in volatile memory is destroyed. And then you repeat that for the next segment until the process is complete. Is that essentially how the technology works?
Yes, that's right.
Okay, and how does the technology destroy the content on the disk?
We're exploring two different avenues on that. One is an actual physical scratching, if you will, of the disk, and the other is more of a laser point oriented. So the idea is that right after the laser is reading that segment of the disk, it's immediately being erased as it passes.
Can I just back up? Is it only limited, does it need to start out on a disc? Or if a film was downloaded or available in a limited download, would that be something that your product could also make use of to convert to your app?
Yes. In fact, it could apply to, if this were a copyrighted image, imagine just having essentially a scanner combined with a shredder so that as it's scanning, it's shredding. It can be anything that can be converted to digital. It could even begin with analog, like a printed picture. We didn't go into those since there was no Section 1201 issue related to taking books, for example. Imagine Google Books, instead of just scanning and letting people search for them, to actually move the entire book to where libraries can loan them.
Well, I think we're going to hear in the next panel how some ebooks do have TPMs applied to them. So if there's it may be relevant if you're trying to circumvent more than audiovisual works. But I think your petition is limited to circumventing TPMs protecting audiovisual works, correct?
That's correct.
Okay.
And specifically on disc.
Okay, so you are not asking the Copyright Office to recommend an exemption for circumventing material obtained via Netflix, or if I download something through Amazon or the Apple Store and I own it myself, that it exists, it's born digital to me, that would not be within the bounds of what you're looking for.
That's right. We do anticipate that as this matures, similar to the way the movie studios eventually embraced video rental that they initially tried to kill, we expect that if this goes forward, there'll be every incentive for a copyright owner in a motion picture to say, look, forget the ingestion process. We'll give you the pristine file, understanding that we give you X number of copies, or sell you X number of copies, I should say, and you'll only have those X number of copies in circulation.
Thank you.
Yeah.
And to come quickly to the actual copies that are in volatile memory. So in your comments and in the presentation, you words like instantly, simultaneously, and immediately. But how long exactly do they stay in volatile memory?
We definitely will stay within the that window that I guess it was Cablevision of less than 1.2 seconds, but certainly not minutes. We're having to base read the tea leaves of case law as to what the courts see as less than transitory duration, or not more than transitory, I guess the way, not more than transitory duration. So if case law were to evolve that allows greater flexibility, perhaps we read larger chunks, and if there are some efficiencies to be gained by slowing down that process a bit. But generally speaking, this would be, we're talking, milliseconds of just reading and destroying data.
And along the same lines, when you say that the data is never in two places at once, is that, again, in layman terms, is that actually true, or is that more that, well, there's not a more than transitory duration in copy in more than two places at once? For example, for however short a period of time, it seems like there would have to be copies both on the disk and volatile memory before the disk gets erased, and then again in volatile and non-volatile before the volatile gets erased. And I understand we might be talking milliseconds, but is your statements about that based on the fact that it's only milliseconds, or is there some other technological process going on?
Well, it's based on two elements. One is, and I guess it's the way Cablevision broke out the two elements. One is the transitory duration. So even if it can be perceived, reproduced, if it's for less than transitory duration, it's not a copy. But second, because of the encryption going on as well, the system won't really allow you to watch that movie in that millisecond of moments that it's on there. So, and because of the encryption, in a way it's, you mentioned the data being in two places. I have data on this piece of paper that has ink. If that same amount of ink were rearranged into a big Rorschach test blob, it may be the same ink, but it can't be, the work that's on this page cannot be perceived or reproduced from it. So it's not a copy of the other, it's just the ink.
Okay. And now kind of going to the thing I'm left with at the end, so without getting into whether the intermediate copies and in volatile memory are copies under the Act, the thing I'm left with at the destination hard drive, why is that not a copy as defined in Section 101?
When you say destination hard drive, are you talking about the consumer's hard drive?
Yes, so I've shifted it.
Okay.
Right, as I understand, I'm shifting from the disk to the hard disk of my computer, the hard drive of my computer, right?
Yes, so one way of saying is that if I download it onto my PC or my Mac or whatever, my phone, that tangible medium is the copy, but it's not a reproduction of the work, I guess is a way of putting it.
So you're not, so you would agree that the destination drive that the media is that the content is going to from the disk is a material object in which the work has been fixed?
Absolutely. Yeah.
Okay, and your argument is that it's not a reproduction under 106.1 because at the end of the process, I'm only left with one thing as opposed to two things.
And I would say, yes, I would say, but during the process, you're still left with one thing. So not, unlike Redigi, where it was a long process, at no point is there a reproduction, and that in reproduction, I think, is very important. It's not a right of production. It's a matter of of reproduction.
So if we've abstracted this to this level, your position essentially is there's always only one thing, but the thing you start out with is a different thing than the thing you end up with.
I don't want to be quoted on saying it depends on what thing is, but
Like you started that one.
It's a different material object, but a blank piece of paper is a material object until you print something on it that may then be a copy of a copyrighted work. So it is a different material object. But from the standpoint of the right to reproduce the work into copies, we believe that the proper reading of that is the right of reproducing the work onto any tangible medium, now known or later developed, and it's not a right to create tangible media that contain works, I guess is the way of putting it.
And just while we're on this particular dialogue, do any of the opponents want to interject anything into this?
I have a number of questions, but it's probably not my role.
I'm happy
Mr.
to
Williams.
speak to a number of these issues. I don't know if you want me to take all of them on at once or just stick to one issue, but if you want to cut me off, just let me know.
Why don't we start with the end copy?
Okay, so yes, I think you can set aside the question of whether the temporary copies that they say will reside in their server for less than 1.2 seconds are actionable copies or not, and they still lose a case under the reproduction right. It's irrelevant whether the server copy is existing for more than a transitory duration, as long as the new material object in which the work resides at the end user's point is a copy. And it's clear that it is. I think he just admitted that it is. And Redigi, as well as the cases who have cited it in support, all say that it doesn't matter whether the original copy was deleted. As long as there's a new copy on the end user's computer, that's a reproduction. And that goes back to cases like Morobi that dealt with an internet service provider using temporary copies to deliver a copy to an end user. They made a very similar argument. The court, Northern District of Illinois, said that's a copy. So I think you can set aside the temporary copy issue if you want to, but I'm happy to talk about that issue as well.
I'm sorry. I'd like to give Mr. Mitchell an opportunity to respond in terms of Redigi and the end thing not being a reproduction, what your basis for that position is.
Okay, and so with Redigi, as I pointed out, it's unfortunate, I think, that the court's language was very broad sweeping. They didn't have our particular process before them. They were simply looking at Redigi's own representations that step one, we make a copy, and step two, we then delete. So Redigi's argument, which I understand they're still making as far as a fair use argument is concerned, that because at the end of the process there's only one copy, this should constitute fair use. But the fundamental difference here is that we don't take that interim step of making a copy and then deleting it. So we don't think at most, the sweeping view of redigi is that language is dicta as applied to a completely different factual scenario.
So your distinction is that you see redigi more as reproduce and delete, as opposed to yours is, reproduce while delete.
Yes, and former Congressman Rick Boucher had introduced years ago, eons ago, it seems, a forward and delete exemption to the Copyright Act that didn't go anywhere, but it was, even the retailers and folks I represented were saying, well, wait a minute, how can you be sure it was deleted? And there was this concern about trust. But the concept was there, and essentially that's what redigi took. We have simply said, look, let's back away from that, let's read the Copyright Act, and let's work through that existing process.
Mr. Williams?
Yeah, thank you. So I think that's just a basic misunderstanding of the issues that were raised in redigi. If you look at the opinion, which I have in front of me, there's a long discussion under the heading reproduction right, well before they get to fair use several pages later. And they go through this exact argument that, well, not more than one copy exists at any given time, and therefore we're okay. And the court rejects that outright and says it's incorrect. It says that it's against the laws of physics to say that the copy that was once on a disk or someone else's hard drive is the same copy as the one that's now in someone else's hard drive in a different location. They go through the dictionary definition of reproduction, and they basically say that to reproduce does not require that the initial copy remain. So I just disagree with the characterization of redigi. They do go on because they found that a reproduction took place to discuss fair use, but the case was not all about whether the temporary copy or more permanent copy in redigi's case was the only actionable copy. The reasoning really turned on whether the copy in the end user's home is a new copy that's resident in a new material object, and whether that violates the reproduction right without regard to what you do with the original copy, whether you delete it instantaneously while you're copying it before or after. That was not the crux of the reasoning there.
If I may briefly respond
Yes, Mr. Mitchell.
on that. So we do have that one redigi case. I admit I don't like it. I think it was at best too overbroad as applied to those very specific facts. But in contrast to that, we do have case law that, such as the CM Paula line of cases that the Supreme Court of Canada relied on to say moving the fixation from one object to another does not involve a reproduction. And
What would you say is the American case that best supports your position? Is this the ink transfer case?
CM Paula, I think, is the most solid one, and the Canadian Supreme Court's the Burge case, however that's pronounced, goes into a lot more detail in terms of the English language. Let's leave aside the value of the case law itself under Canada's Copyright Act, but they do go into several pages of explaining what a reproduction is based on the English dictionary. And our Copyright Act recognizes this when in the very definition of fixation, they talk about, when you're reproducing this into a copy, they then had to say, oh, wait, under our definition, the original copy, if you want to talk about the original copy that the author wrote out, that's not a copy. So they had to tack on to the end of the definition of fixation, oh, by the way, this includes, we will call it a copy even though it's not a reproduction. So the Section 101 definition fixes that little part of saying it's not a copy if it's the only original one, because there's no reproduction. There's no exercise of the exclusive right to reproduce the work into copies. It's the first one. There's no reproduction. I see you puzzled over that.
I'm going to pull out my book and let Mr. Williams speak to that while I look at it.
I'm not sure I'm following, but if I am, I think that is incorrect. So the statute has two definitions that are admittedly not that easy to unpack, but so the definition of fixed isn't just really a definition of fixed, it's what it takes to be fixed in a tangible medium of expression so that something becomes a copyrightable work for the constitutional purpose of actually being copyrightable. So it's not really just a definition of fixed, and if you look at that definition, it even refers to that being done with the authority of the copyright owner, which clearly that's not the type of copying he's talking about. So there's some language in there that's a little hard to parse, I think, because really what that definition is trying to do is focus on copyrightability as opposed to reproduction. If you look at the definition of copies, it's distinct, and it doesn't refer to the transitory duration language for one thing. It just refers to perception or reproduction or communication through a machine or device. I think the other language that you're referring to is one of two things. In the fixation definition, there's a sentence on the end that basically says for broadcasting, if they're simultaneously recording it as it's being broadcast, you can treat that broadcast as a copyrightable fixed work. That's just not an issue here, it's a separate issue. The other thing is that the definition of copies actually says at the end, the first fixation is a copy. So I think you said the opposite, and I believe that it says the term copies includes the material object in which the work is first fixed.
Mhm.
So that is a copy at that time, even though there is only one of it.
And that was essentially the point I'm making, that language is superfluous if that was already somehow included in the term copies. The focus here, I think, and it might clarify a little bit, it's the right of reproduction. What is the right of reproduction? The right to reproduce the work into copies. And when we look at the definition of copies, it does use the word, it's embodied, there is a fixation requirement to be a copy. And Cablevision, Cartoon Network, however you call it, was very clear in that there are these elements that you make to say, has the work been reproduced into a copy? Maybe that's the bigger mouthful to say, has the work been reproduced into a copy? We cannot simply ignore the reproduction part by saying, here's a copy, it's a different tangible medium than the other, therefore it's a reproduction. The Copyright Act just doesn't work that way. It's a right of reproduction.
Mr. Williams, I see your placard up. We'd like to move on to adverse effects, unless you have something very brief to.
I would like to just, unless you're going to come back to it, I would like to address.
I'm just mindful of the time. If
Sure.
there's time at the end,
The
we can
transitory
come back.
duration issue, though, I haven't really talked about yet, so if you'll come back to that at some point, I'm happy to move
I think
on.
now would be good to say what you would like to say about Cablevision, and then we'll move
Sure,
on.
sure. So I won't repeat everything in our filing about, the differences between the Copyright Office's previous conclusions and Cablevision, but I do want to point out a couple of things about the statutory text that call Cablevision into question, in addition to all the other cases that have not applied the law the same way. And so one is that if you look at the definition of fixation, the only place where it refers to a period of more than transitory duration is after the words otherwise communicated. And there's no comma after otherwise communicated. So even if you wanted to say that otherwise communicated requires something that lasts for more than a transitory duration, there's no reason to read that definition in a way that applies that same qualification to perceptible or reproducible instances of the work. And so I don't think that there are necessarily two prongs to that test. If you look at the definition of copies, for example, there is, after the phrase otherwise communicated, a comma, and then it says either directly or with the aid of a machine or device. And that then applies back to all of the previous terms that are referenced. So that's one statutory way of reading it that would not require a period of more than transitory duration. Another way of reading it is that it's not just that the temporary copy has to exist for more than a period of transitory duration, but that the copy that is enabled downstream from it is capable of existing for that period of time. And that's the way that the plaintiffs in Cablevision presented the case. Judge Forrest, who's now on the Southern District's bench, wrote the brief, and I would point you to that as another way of reading it. And that all, again, sets aside the case law and your previous conclusions. I think you know why the analog cases are inapplicable, but I'm also happy to speak to that if you want me to.
I think we're okay moving on.
Could I respond briefly just to say that this may be a novel, interesting argument to, Cablevision is pretty well the standard I would go with, and the burden would be on the copyright owner in an infringement action to explain to some new court that Cablevision was wrong and should not be followed. But I don't think it's the purpose here for the Copyright Office to overrule Cablevision, that's all.
Thank you. Shift.
We're not overruling any court.
I understand. I'm not suggesting you are.
Shifting gears over to adverse effects. So as we understand it, and as I think you just said earlier, OmniQ's technology is not currently available and on the market, correct?
Correct.
Do you have any idea when yours or someone else's comparable technology might be available for use?
It's sort of like my wife asking when I'm going to finish the project around the house. We've been going in various, some elasticity on our projections. We had started out more optimistic. As we've explored opportunities with different funding entities or different partners, such as delivery over wireless, it seems we get caught up quite often, and the reason we're here is, wait a minute, I want to see how this shakes out in terms of you're getting over this one hurdle. So at this point, I don't have any projections as to when. We're still meeting pretty regularly to push that boulder uphill, and do have conversations going on with potential partners and funding sources, but we don't have a market plan yet to bring it to market. And
just to clarify, so the reason you're asserting is a fundraising one, as opposed to a technological one?
Yes. From the technological standpoint, we've actually planned that out on a fairly short period of time. The engineers that would need to be hired, and we're talking just a matter of a few months to pull the technology together, because the technology itself is primarily built from existing technologies out there.
Does it already exist in beta?
No.
Okay. And you don't have a schedule to that, because that would be dependent upon the funding?
Right. And again, even that would be dependent on how do we need to make the reproduction. So from the engineer standpoint, they would say, look, all we need to move is the movie, and if you have a disc that has different language tracks and bonus material and so forth, those other works are not the ones we want to move. But if we had to do an entire disc image in order to move this without touching the CSS, then it becomes a lot more bloated and inefficient and that sort of thing. So sorting out some of these questions are fundamental to how exactly we develop the project.
Okay, and Mr. Chatfield, so your interest is just is not in your company engaging in circumvention, because you have protected the whole CSS, as Mr. Mitchell said, or AACS, is that correct?
Yes, my company is not involved with any form of circumvention, and we don't even touch the original content in CSS or in AACS.
Okay, thank you. I'm just trying to understand what potential uses are at issue in this class. So
well, if I may just add that part of this actually is involving the capability to actually render the original disable it. And we do have technology in that area that automates that process from an optical disc.
Thank you, Mr. Williams.
Yeah, I'm sorry, I don't mean to keep interrupting, but I just don't want to let everything go unresponded to.
No, I do think, I will say for the two who have not spoken yet, if you want to speak, just tip your placard up, and, this is getting a little more nitty-gritty than some of the classes, but feel free to chime in so we can make sure everyone's heard.
Sure. I just wanted to respond to what you were saying about what's at issue in this class. From my point of view, the Solobyte technology is not at issue here. It was never submitted into the record. There was a one-page reply comment, and then we hear it for the first time today about all of this. He says there's no circumvention, so you can't grant an exemption, of course, where there is no circumvention at issue. It sounded like what he was asking for, and I saw one little bullet, but I don't think he mentioned it expressly, is that he wants an exemption to allow him to circumvent all the DVDs he wants to create master copies that he doesn't have to get licenses for, so that then when he uses his laser to destroy everyone's disc, he can sell these copies to his users. And that would require an exemption, and it would be a very, very misguided exemption that I think would run counter to everything the office has ever had to say about space shifting. He referred to licensed transactions, but if he needs to circumvent to get the master copies, he must not be coming to my clients for the licenses. So I'm very confused about that service, but I don't think you need to get into it because it's really not in the record.
Can I respond to that? So we have approached your clients and have detailed conversations with
You
respect
can just speak
to,
into the microphone. Thank you.
Thank you. With respect to licensing the replacement content. And the clients actually are requiring a significant amount, so it's basically an impractical request. From a funding standpoint, they require a significant amount of payments up front, guarantees to license the content for this use, plus the vast amount of sources. So there's so many sources of this original content that are owned that it's very difficult actually to license all the content from all these different sources. But if you just set aside, if you're looking at the studios, for example, the majors, the 6 majors, we have approached 4 of them, and we continue to hear that they're happy to license the content, but they require a significant amount of upfront money, which is basically funding infeasible from a business perspective. We found it very, the investor perspective on this is there's 2 huge roadblocks to progress in accomplishing this. One is the amount of money that is required in investing in this library of, basically you're just investing in getting contracts with the studios, So the other part of this is ambiguity. If there's ambiguity in terms of, well, are we going to be able to take the other course, which is, should there be an ability for the consumer to actually, or to be able to make these master copies? Some would suggest that there should be under a fair use, then really there's no money to be made until that's clarified. So we're asking the librarian, the Copyright Office, to grant an exemption that would allow the creation of these copies so that the consumer can exercise their fair use rights of making their own personal copy. The consequences of this from a fair use perspective is low. I mean, in terms of the market and the 4 tests, it's very low. I mean, so basically we keep the content in a secured form. We actually improve the security of the content that exists today. Therefore, we reduce the consequence or the risk of piracy. We keep the honest people that want to just create a library and archive of their content, we give them the capability to do that. We do not believe that the DMCA, can I finish, should be used to create a toll booth for the consumer's legal right to make a fair use copy. Basically, that's the position.
I do
that we
agree with
promote.
Mr. Williams that this was not submitted in your written comment, and it's difficult to understand the business model you are projecting now, but I will let him respond on this. And if you could perhaps speak to licensing, it sounds as if, if this is something valuable to the copyright owners, that might be useful to understand whether they are not willing to license, and if so, thank you.
Sure, and I'm here representing MPAA, the trade association, and as you know, they're all competitors, so I can't get into the specific licensing practices or negotiations of each studio, but it would not surprise me that if they are willing to license, as he says they are, that there would be a significant investment required to get a service up and running. That's only the way it should be, given the value of being licensed to sell some of the most creative, expressive works in the marketplace. That doesn't mean services can't get off the ground. We've got several pages in our opposition comments listing all the various licensees who are already in the marketplace providing the exact same kinds of digital copies that Solobyte claims it wants to provide. It's very similar to disc to digital. It's very similar to Movies Anywhere copies. It's very similar to a bonus pack copy that's supplied with a Blu-ray disc. And the Copyright Office has looked at all of that a number of times in the past and said that really, market demands are being met, and that these types of unauthorized, unlicensed businesses create market harm under the fourth factor. I'm not going to walk through all four of the factors, but you've done so a number of times, and all four of them weigh strongly against this type of business model.
Mr. Trumbull?
Yeah, I would only add, first of all, I think we would echo what Mr. Williams is saying, so our silence isn't misunderstood. But a lot of our focus was on exactly how does this technology work and does it work? And I think the discussions that's gone back and forth here just before demonstrates, number one, that the technology does not actually exist in any kind of demonstrable form. And secondly, the discussion from Solobyte suggests a very different kind of analysis, a fair use analysis, which again is something that you all have looked at repeatedly and said no for a librarying, if you will, of copies circumventing the technology. The other thing is that it's not at all clear to me where the circumvention actually takes place, because is the copy coming off the disk still encrypted with either CSS, and I know Mr. Mitchell has now limited to DVD, although their statement talks about Blu-ray repeatedly and AACS repeatedly, so we responded that as if it also covered AACS and Blu-ray, but it's not clear whether the copy that's made retains the original encryption, and then there's circumvention of the technology from the server copy, or whether the copy is decrypted as part of taking it off the disk, which is done not in the drive but separately. So it's very confusing.
I wonder if they know the answer to the technology. Mr. Turnbull's question?
So one point of clarification, if I said DVD to the exclusion of Blu-ray, that was simply referring to all, Kleenex as a generic. I meant the optical disc. So the only optical discs that we've talked about specifically are DVD and Blu-ray. We haven't talked about 4K technologies or those, but I did not want to suggest that we were abandoning the Blu-ray portion. There are a couple of I think there's an effort here to have us chase the wrong rabbit. That is, we presented the technology of how we would accomplish this, but fundamentally the question is if someone can, perhaps perfecting, coming up with a different way of doing this, can actually move the fixation from one material object to another, just like was done in C. Impala, using chemicals to lift the image and put it on another. If someone can do that, the exemption should apply to the non-reproductive moving of the fixation from one material object to another, not we're granting an exemption to OmniQ. We're not, so, I mean, I don't expect to ever see the regulation saying this is only limited to to OmniQ's patented technology as presented. It's the legal concept that if there is no reproduction going on, what is the right that's being infringed? So I think with that being the proper focus, and then there was an interesting case, Grady versus Yaculo, April 18th, 2016 case out of the District Court of Colorado, which followed Cablevision, noting that its own district court had not followed Cablevision's definition. But they point out that the party with the burden of proof, it's the plaintiff's burden to provide evidence that defendant's conduct constituted copyright infringement, or more accurately, the defendant's sharing of the thumbnail images resulted in the same being copied to RAM of the defendant's computer for more than transitory duration. So even as we get into issues of transitory duration and that sort of thing, it's still the plaintiff's burden to show that a reproduction actually took place. And I think it would be improper for our technology to be held back because we first have to go to court and prove that our technology does not infringe. It doesn't work that way. There's a First Amendment right to get these things out there, and while the Copyright Office, the Copyright Act is an exemption to some extent to the First Amendment, it doesn't obliterate it. And so unless, and the Supreme Court's been clear on this, unless the copyright owner can point to a specific 106 right, and there is no 106 right of access, it's a reproduction right, and that's where the focus should be. If we can accomplish this without reproduction, the exemption would cover us. If we try it and fail and get sued for infringement because we ostensibly use the exemption, but it didn't work the way we had planned, or a court rules that we did it in 2 seconds as opposed to 1.2, and that's too long, so be it. But that's something for the courts to decide as to whether we pulled off. All we're looking for is the exemption to use the Copyright Act in a way that doesn't touch on any of the exclusive rights of the copyright owner.
So to that point, we've said in this proceeding pretty consistently that we're not supposed to break new legal ground, and so we've pretty consistently looked for, controlling or at least pretty substantial precedent, before we're going to take the step of saying that something is likely a non-infringing use. I know you addressed this to some extent in responding to Ms. Smith's question about sort of what the strongest case you have, but can you sort of respond to that concern about, whether we would need to sort of be going out on a limb given the state of the case law? Can you give us anything, is the best case, I guess you answered this before, but can you give us anything beyond the case about moving the ink, the Canada case you mentioned, that would sort of give us some sort of solid legal basis for reaching the conclusion that you're asking us to?
Yeah. And I started to go down the path of looking at all the Canadian cases that have followed the Verge decision. It's very solid law, not been questioned in Canada, but again, that's Canadian law, so I've left that aside. But C. Impala has stood the test of time, and in cases that assessed whether C. Impala applied, the courts have been able to make the distinction, for example, when the image was used as a backdrop to layer on brush strokes and so forth to actually oil paint over the photograph, to say, well, wait a minute, that's a derivative work. That's something different because you're essentially using the original to trace out or to make the copy. But there's been no, there have been other cases that have followed C. Impala, essentially are making that distinction. Are you doing what happened in C. Impala or something else? But the fundamental piece here, I think, is from the Copyright Act itself in 1976. Congress did try to future-proof it, and that language of now known or later developed, the idea is to have these principles apply. So if something applies to ink on paper or to grooves in a vinyl record or to magnetic impulses on a cassette tape or to however it's done with the DVDs, no matter what the technology is, the principles should remain the same, and that seems to be what Congress was trying to establish when they said, oops, we left out piano player rolls, let's just now say any technology now known or later developed. So when we simply reverse that, if in fact the court is making law based on one technology that was developed at that time, the same principles should apply to any technology now known or later developed. And if Congress, as it did with record rentals to create an exception to the first sale doctrine on certain computer software and rentals, Congress was the one to come in and say, this new technology changes things. We're going to change the Copyright Act to create an exemption. The public performance right and digital performance right in sound recordings was one where, again, Congress could have simply said, it doesn't apply, and they thought, well, for digital, we'll make it different, and their distinguishing factor was digital. But that's Congress's decision, and so right now, I would say you take the precedent and apply it to any technology now known or later developed.
Yeah, and I appreciate that, and I don't want to belabor this, but I mean, you raised this sort of point about, this is sort of, reminds me of sort of the analysis in area, do we look at sort of the behind the curtain, functionality of what's going on here, but I wonder which way that cuts. I mean, if it's sort of well established that the reproduction right gives the copyright owner the exclusive right to control the making of copies of his or her work, and it's well established in the case law that we don't care what happens to the original copy so long as, there are reproductions being made. Why should it make a difference that, whether the destruction of the original happens a few minutes later, or a few seconds later, or in your case, almost simultaneously? I mean, if we are to sort of take your lead and analyze this from sort of, the perspective of not looking at sort of the behind the curtain technology, but what's going on here, I wonder if that sort of helps you in the way that you're arguing.
Yeah, I sort of go back to Rick Boucher's forward and delete technology. That was a decision Congress could have and rejected a proposal to say, look, if you forward it to someone else, that's okay as long as you delete it. That's a call Congress could make.
Doesn't that also not help you, since that was a bill introduced that was not passed?
Well, I think it's neutral in terms of whether it helps us or not. That is, clearly that will involve making a copy. You share the copy, someone makes a copy, and after that's done, you delete it. So if it's more of the redigi type of situation, if you made the copy first,
but wouldn't
then you delete.
if Congress saw a need for that kind of amendment, wouldn't that imply that the current act doesn't permit it?
Well, the current act would not permit what Rick Boucher was suggesting of me forwarding you my copy of the movie and then deleting it. I agree. So we needed a change on that. But when it comes down to the technology being used, if someone says, I give you a license to reproduce my haiku poem, and that's the license, do I reproduce it on the back of my car or on a piece of paper or somewhere else? It's a licensed reproduction of that poem onto something else, but the Copyright Act doesn't cabin the copyright owner's rights to say you can only exercise your rights with certain technologies, nor does it limit the users on the other end to say, well, if that technology didn't exist at the time the act was passed, all bets are off.
Actually, I'm sorry, I interrupted you, and I don't know if you had more to say in response to Mr. Amer's question. I just wanted to make sure you felt that you could address his question.
Okay, thank you. And there's been some water under the bridge, so maybe I should turn it back and say, did I miss one of the points?
No, I think we can move
Okay.
on. Thank you.
I didn't want to be responsive. Thank you.
I would like to add. Can I go ahead? So it's, from what I understand, Kevin, your position is that Copyright Office cannot create laws, so we started this conversation around the issue of creating law, it appears. That's what I heard you say, or that was the issue you sort of introduced to start this?
Right, I mean,
Broadly.
we've generally, yes, I mean, we've just said that, we don't break new ground in this proceeding and sort of go out on a limb beyond, get ahead of the courts in determining non-infringing uses.
But you do have the authority to actually grant these exemptions and interpret areas of ambiguity in the law and provide interest and provide input in counsel to Congress, correct?
So the Copyright Office serves a variety of functions related to copyright law. So we do advise Congress when requested on ways to change the law in terms of the Section 1201 rulemaking. We need to address under the statute, our regulatory authority asks us to look at whether the activity at question is likely to be non-infringing. And so based on that, we have said we are not looking to break new ground onto ways where something may or may not be non-infringing, but we have also said there does not need to be, an exact dead-on case on point in order for us to draw an inference as to whether something is likely to be non-infringing or not. So our past Copyright Office recommendations, as well as our 1201 policy study, sort of goes into the standard the office will apply when we evaluate the exemptions.
So it just seems very difficult to understand. In some cases, it appears the Copyright Office is quite active in interpreting, in helping to interpret law. In other areas where it decides that it's outside of their scope. So let me reference just in this Section 104 report that I'm reading right now, the Copyright Office provided to Congress. For example, quote, "We believe Congress intended the copyright owner's exclusive right to extend to all reproductions for which economic value can be derived." So what I'm hearing there is you're acting as interpreting the law. You're helping to clarify and de-ambiguize the law, if you can use that term, in this case. But, much of this is it's muddied, it's gray. And I think what we're asking is that there should be some part where we're here really because we believe the Copyright Office should take a stance on certain issues that are somewhat ambiguous, but then I'm hearing that the same token that, oh, maybe that's beyond our scope in this case, So you got to have it one way or another. Either you have the ability to interpret and make decisions, or you don't. And it appears there's precedent that you have been making interpretations, and then in certain cases, you fall back to, well, I can't interpret that because that's beyond our scope. So that's inconsistent in my mind.
Okay, thank you for your perspective. Mr. Williams?
Thank you. I've got a few different points I want to address based on what was said. I'll start with the last one here. You wouldn't only be creating new law to try to grant one of these exemptions, you would be rejecting existing law. The VidAngel opinion just endorsed all of the Copyright Office's prior hesitancy to say that space shifting is a fair use. And so certainly with respect to the type of copying that SoloByte is describing, and I also believe the type of copying that OmniQ is describing, there is no fair use right there to that type of copying. The C. Impala case, Mr. Mitchell said it stood the test of time. I'm not so sure that that's true. The Redigi court said ignoring the questionable merits of that court's opinion and then went on to explain why it's distinguishable. And it's clearly distinguishable because there, as the Redigi court said, a material object, a copy, was lifted off of another material object and then put onto a new material object. So the courts have consistently referred to what was transplanted there as a material object in itself. When you're dealing with redigi or with what OmniQ is describing, the two material objects at issue are the two computers on either end, or the disk on one end and the computer on the other. And the courts are consistently saying that it doesn't matter what happens on the front end, whether you delete it or win, as long as there's a new copy on a new material object at the end user's point of delivery, that is a reproduction. So you can set aside, as I said before, the temporary copies. I do want to try to explain why those temporary copies were so important in Cablevision, because it's different than what we're dealing with. In Cablevision, the court had decided that the end user who was operating her own DVR was making the permanent copies that were to later be viewed, and the parties had also set aside the fair use argument over those copies and whether there was some secondary liability for them. So when Cablevision, when that court was looking at the buffer copies that supposedly only lasted 1.2 seconds, it wasn't also going downstream to say, and they resulted in another new copy, which is clearly actionable. The consumer was being treated as the one who made that copy. And therefore, all they were looking at is, are the ingestion buffers that the Cablevision system creates in order to facilitate those decisions by the consumer, are they actionable? And the court said they weren't. I disagree with that decision, but they said they weren't. Here, the copy that is delivered is being sold by OmniQ to the end user. And so those copies are not off the table. And so even if you don't want to reach the issue of the temporary copies that are created in between the disk and the delivery, OmniQ is still on the hook for those copies that it's selling, and they're clearly lasting for more than a transitory duration. The only other thing I wanted to get to is this notion that somehow the Copyright Office is standing in the way of Congress's intent to allow technology to develop over time, and the technology we're dealing with here is not something Congress has ever thought about. It's just incorrect. When the DMCA was passed, Congress foresaw these issues, asked the Copyright Office for the report that was being quoted. The Copyright Office delivered that report to Congress. Congress chose not to create a digital first sale doctrine. The Commerce Department has more recently looked at this. They've also endorsed the notion that there does not need to be a digital first sale doctrine because the marketplace is providing benefits that go far beyond what these types of digital first sale business models would provide. And that's been endorsed actually even in the recent Red Box opinion. The judge extensively quotes from the 104 report and says there's all kinds of policy reasons why you wouldn't want to go there with respect to digital first sale. So I don't think it's true that Congress passed the statute in 1976 and instructed the office and the courts to just treat every new technology the same. Here, they specifically knew that these types of business models might not be allowed, asked for policy input from the relevant agencies. They've received that input, and they have not created a digital first sale doctrine. Thank you.
Mr. Trumbull. Again, I endorse what Mr. Williams just said. But the point I wanted to come back to again is that the setting for this proceeding is that you have a circumvention prohibition, and there are technologies such as those developed by Mr. Taylor's and my clients that rely on that circumvention prohibition. And then the question is whether there are particular identified non-infringing uses that may be harmed by the imposition of the circumvention protection for our technologies, and where there are, I've forgotten the lineage, but the litany, but identifiable, demonstrable harms that have been brought forward, then a narrow, specific exemption may be granted. Here, what we have is a theory and a questionable legal basis for the non-infringing use. What we have sitting here are representatives of the people who would be harmed if the exemption were granted. And, in our view, it's the way the Copyright Office and the librarian have evolved over the 20 years of this proceeding is that the take into account, what are the effects on the market that the DMCA was intended to create, as well as the alleged adverse effects. And so we think here, if you're looking at the balance, what you have is a theory and a maybe and a stretching of the law versus a very clear demonstration of harm to the technologies that would be circumvented.
Can I ask a follow-up question there, if I could, and whoever would like to speak to this? One of the things that I think has come out in a lot of these proceedings is where the harm may lie. And this one, we've talked a lot about harms to particular business ideas. Is there an adverse effect for consumers here? And I think that goes to some of what you just talked about, Mr. Turnbull. If there are a lot of alternatives in the marketplace, is there a harm for consumers in this space for being able to make this copy? If they have, for example, when they buy a DVD or Blu-ray today, it often comes with multiple copies on that disc. We didn't talk about what happens with all of those multiple copies on the disc in these technologies. Can you sort of speak to those harms to the consumers, which is one of the things that would be considered in this case? Thank you.
I mean, first, what I'd like to say is that the consumers have been incredibly benefited by the circumvention prohibition in Section 1201. The whole DVD market depended on it. The whole Blu-ray market depends on it. And what has then happened is that as other technologies have come on and the possibility of making other copies or having hard drive copies or having copies in the cloud have evolved, the marketplace has developed. And I think Mr. Williams' submission, has many examples of how the marketplace is moving to fulfill those desires by consumers. But the first and foremost benefit for consumers is the existence of the DVD and Blu-ray market in the first place, which depend on the circumvention prohibition.
Yes, thank you. I agree that the harm to consumers would come from granting this exemption, because it would, as the Copyright Office has concluded previously, essentially undercut some of the most exciting business models that my clients are putting into the marketplace. Consumers right now are getting far more bang for their buck than they would just from the simple right to rip a disc. They're getting access to a lot of offerings at low price points that really wouldn't make sense in the market if every single disc could just be ripped and the copies could be passed around. And so you can get, if you look at our filing, we try to run through almost all of the options right now, but it's everything from a very short period digital rental to an on-demand through your cable subscription to a disc, as you say, that comes with access to a bonus copy. Those bonus copies can be stored in cloud services like Movies Anywhere. That can be shared with your family. There's all kinds of benefits that are growing out of the fact that authorized access models and licensing models are able to take root. And if they are undercut and a copyright owner has to consider how to extract full value from that first sale for fear of losing the pieces of that value along the way from unauthorized copying, it's hard to predict the economics of the marketplace, but it's quite possible that prices would go up in the first instance and a lot of these lower price offerings wouldn't be available.
Just a quick follow-up question, and we'll get to it. Would the fact that a copy of a work that's circumvented is then re-encrypted, does that affect anything in terms of any dangers? I mean, it's a little different, seems a little different than the traditional argument against space shifting that you now have an in the clear copy. How would re-encryption affect any of the analysis, if at all?
I don't think it affects the fair use analysis at all or the reproduction right analysis. Of course, we'd rather have copies that are protected instead of copies that are in the clear. On the other hand, you know, I don't think my clients are coming to SoloByte and asking for their encryption, and it sounds like OmniQ is using a piece of encryption software that's already available in the marketplace. So to me, this idea that somehow they're doing us a favor by giving us a higher level of protection is just a red herring. My clients work with very sophisticated technology companies, including Bruce's clients, to try to provide the protection that they're comfortable with.
You don't think it has any bearing on the market harm analysis?
Well, there would be increased market harm if the copy was in the clear and was further copied on and on and on. Although, if you look at OmniQ's proposal, they say they want to offer the biggest video store ever. So my understanding of the model isn't only that the individual consumer would get rid of their disk and have one copy that's now encrypted. What I think OmniQ wants to be able to do is hack the circumvention, get a master copy essentially that gets moved back and forth to different consumers in a video store model. So regardless of whether that copy remains encrypted throughout the process, there would have been one sale that would then result in thousands and thousands of views of that one piece of product.
Mr. Mitchell.
Thank you. A lot of water went under that bridge, and I'll try to touch on a number of those pieces, but I think that last description is exactly how video stores operated. They could rent the video over and over. Public libraries rent the books until the covers fall off and then rebind them.
Mr. Mitchell, if you could add to that, did they have a license to do so?
No. And I've actually dealt with video retailers who are renting and get a demand from a small copyright owner saying, you need a license to rent my videos just like Blockbuster does, and don't realize that Blockbuster doesn't need a license. So you buy the movie, and what we saw with the video industry was back when the MPAA was trying to persuade Congress to create an exception to the first sale doctrine for rental, they were proposing a one-night rental will be about the price of a movie theater ticket. That sounds fair to us. And what we've seen is that they started selling VHS tapes for $75, but video stores were renting them for $3, $3.50. As time passes, we end up with Redbox renting for 99 cents. All of these were lawfully made copies purchased by the retailer and rented. In terms of the original value, that's up to the studio to decide, but certainly they weighed that factor. For a long time, we went through what was called sell-through pricing and rental pricing. If the studio thought this is going to be a hot rental item, they would have a high initial purchase price. And then, but if it was something that they thought grandparents would want to buy for their children or grandchildren, they would drop the price so that you sold more copies. So this comment about capturing that value of the original copy, that's exactly it. What we're seeing right now is the shift is that the consumer is losing that value because you've now got a bookshelf full of DVDs, but your DVD player died and you've got 2 subscription services, so you're not going to invest in that. What do you do with the discs? Or some other situation where you simply you want to gain access to those copies that were already sold at whatever price, but now they're essentially becoming obsolete and in terms of the technology to play it back. So I wanted to briefly go back to Matthew's original comments on speaking a lot about temporary copies and buffer copies. That's an oxymoron, and that's one I think it's important to keep clear. A temporary copy is an oxymoron when we're looking at the Copyright Act. And I think here's what OmniQ has been trying to do is be very precise with respect to the Copyright Act. There are a lot of terms in use Studios will talk about distribution, which isn't distribution in the 106.3 sense, but it's distribution like theatrical license to publicly perform. That's part of distribution. But when it comes to copyright infringement, we need to be careful to know what we're talking about. And to say temporary copies begs the question of, wait a minute, it may be temporary, but the question still remains, does it fit the Cablevision explanation of what a copy is? With respect to the DMCA, Senator Hatch in his introduction was very clear. This was a minimalist bill to try to implement WIPO, the WIPO Copyright Treaty. The WIPO Copyright Treaty says we can do this. That is, put it a different way, it says the United States does not have to prevent circumvention in a case like this, because the WIPO Treaty says you have to have laws that protect against circumvention that's not authorized by the copyright owner or by law. So the standard there under WIPO is that if it's not infringing, you don't have to have a prohibition on circumvention. You're okay with WIPO. Congress left off the or by law portions, but they did tuck it back in Section 1201C, saying, hey, we don't intend for this to change any of the balance. And now what we have is a big imbalance where the Copyright Act says, I have this right, but the technology has progressed to a point where the copyright owners can favor the methods of dissemination that don't allow that right to be exercised.
Okay, thank you. We appreciate all of this commentary, but just because we are running short on time, I think my colleague has another specific follow-up question for you on the video store rental, and then we may get around to sort of last call to tie up the issues we've been teeing up, unless anyone else on the panel has further questions.
There was the question of harm that I just wanted to observe that from Mr. Turnbull's client's perspective, I don't think the DMCA has anything to do with protecting harm to their industry if it becomes irrelevant. And the work is protected even more so, as we pointed out. Any DVD can be ripped and multiple times and copies shared. With our technology, we lock that down so it's only one. I don't think the copyright owner can necessarily do what we're doing, because it might involve an enlargement of their Copyright Act to say, we're going to lock things down in a way that gives us control. There is no right to destroy copies, for example. There is a right to reproduce the work into copies, but there is no right to destroy the copy owned by someone else. We see that happening every day, though, where there are these temporary downloads, and after a certain time, the copyright owner jerks it from you.
Thanks. I just had a quick follow-up question about the video store rental model that you mentioned. Mm-hmm. What's your, I guess, plan in terms of collecting the works to implement something like that? Or are you looking to go out and buy lots of DVDs and Blu-rays and shift everything? Or are you planning more of a public release of your shifting software through an app and let people shift their own stuff, which then they can sell to you, which then you'll reshift as you sell down the line? Which kind of model are you contemplating?
Okay. We know we need to launch with a big influx of movies, and one of our partners, Mark Freeling from Seattle, just recently closed one of the biggest stores in the country with 30,000 titles. I've forgotten that. It's just an enormous amount of titles. But through both his video store, he still kept those videos. We have already a number of videos to be ingested. But then there are a number of, particularly as video stores close, there are a number of warehouses where middlemen are trying to pass off the used or surplus or never sold in the first place videos, and the prices are attractive. We do expect, though, particularly with new releases as they're coming out, yes, we would buy those. We've talked about elements where we can sort of the shared economy of Uber and Airbnb, the notion that, hey, if you've got these videos sitting on your shelf and you'd like to put them in the economy, send them to us, we'll give you credits for rentals, and we'll ingest them into the system with everyone else. And in fact, I should say we've even considered having fan-based groups where someone could say, hey, rent my video collection, and we would be able to track if the customer came through that recommendation, give additional credit to the person who's drawing more attention to those titles.
So just to be clear on that last part of it, so would you be basically asking them to send you their discs, or would you be providing them the means of using your technology?
We would be asking them to send us the discs. We don't envision in the near future a means of having consumers do the ingestion process. We do hope that in the next phase, consumers might be able to, once they've received it from us on their hard drive, might be able to, essentially from a consumer perspective at least, be able to pass it to their neighbor using our technology, but it might mean a going back up and then back down.
But that reshift would be limited to content that was originally obtained through your store.
Yeah, so there are only two ways we could get the movie, the content in our store. One is by purchasing or receiving as a gift, technically, but becoming owners of the discs ourselves and ingesting and destroying. The other is where the copyright owner says, skip that process. We'll charge you a few bucks extra for the value that you can skip that process, and if you'll pay us this extra amount, it may be worth the headache to do that. And I should say, studios have been ready to do that with various merchants. Netflix, when it was doing the disc rental, and Redbox don't need the jewel box, so here's a different deal if you don't need the jewel box and all the packaging that based on your model.
Thank you. Just because we are long on time, I believe Mr. Turnbull is next.
Very briefly, I just wanted to dispel the notion that either DVD or Blu-ray is going away anytime soon. Both are going strong. Both organizations are very strong and vibrant, and we expect to be in existence for many years, certainly well beyond the next 3 years before the next cycle here.
And OmniQ is thrilled to hear that.
Thank you. I believe Mr. Williams was next.
Okay, thanks. On this video store question, like Bruce just said, DVDs, Blu-rays are still in the market. If people want to open video stores, they can. What OmniQ is proposing is vastly different from a traditional video store. And the Copyright Office and the Commerce Department and numerous judicial opinions have all acknowledged that physical product is different from digital product when you're talking about essentially allowing large numbers of consumers to retransmit the work over and over and over again. So it's not that you drive down to a Blockbuster, rent the physical disc, drive home and watch it. Literally, each time the first user located anywhere in the country or anywhere in the world, depending on how they set this up, each time one person stops watching it, another person can start watching it. And so it's geographically distributed, and there's no limitation on how many times that will occur, whereas with a physical product, eventually it's going to run out of steam and it's going to break or it's going to get scratched. There's deterioration, and all of the people who have looked at this carefully have said that this type of offering would cause dramatic harm to the copyright owner in a way that was never anticipated with traditional first sale, which is based on an idea that you shouldn't restrain the alienation of physical products. The only other thing I wanted to address is Mr. Mitchell brought up the WIPO Treaty. On page 15 of our opposition comments, we have numerous international and bilateral agreements that we refer to that require our country to protect temporary copies, and so we would just direct you to those on that point. Thank you.
I will say tomorrow we have a panel that is directed towards issues of obsolescence and degradation in the digital age, so maybe we can save some of that discussion for them. But since we're 1 minute, Mr. Trashfield, then Mr. Mitchell, and we will wrap this up. Okay? Thank you.
Okay, I feel that just to provide a balance here in a reality check on some of the comments that were made with respect to consumer harm. So in my presentation, there's significant information in there about the counters, some of the information that actually has been provided here by Matt in the MPAA. So one is that there's an abundance of sources for this content in digital form on the web or through other outlets. we're talking from there, while there are many sources out there, it is absolutely impossible for the consumer to actually get all the content that's on home video available online from web sources, especially in an affordable manner. What would require that the consumer would have to subscribe to multiple services, and many of them, and that would be very cost prohibitive. Okay, so another was mentioned, and this is also in my presentation that I wasn't able to actually give, is that if you can refer to it, basically disc to digital, which we pioneered as a company before it was picked up by Walmart and Vudu and used in a different way, actually is still not a real solution because there's so many titles that are not available on disc to digital. Furthermore, it doesn't, there's been mention of redemption tags and things like that that are available in the MPAA article or submittal. These redemption tags are only available for new releases in UV or now in the UV system. What about the billions of discs that already exist that never had a redemption tag? The consumer's left with no outlet for that. So when we're talking about widespread harm to the consumer, it's dubious for me to think that is this about the comments about the DVD CCA and the MPAA and the industry being harmed. When we're talking about the exercise of law here that is preventing the consumer from making their right to actually make their private copy, and the only way they can actually get anything close to that is actually in a disc to digital transaction, where now the few outlets that offer that are charging people $2 just for the right to make a copy. If you go to Vudu and you have a disc, if you can find it available on disc to digital, they're charging you $2 to get an equivalent copy in digital format. That's basically hostage of the consumer's right to make fair use copies. And we don't believe that's really, we call that basically, you shouldn't be calling media ransom, basically in the industry for the consumer to exercise that right. The right they need so they can future-proof their content when platforms are in decline, which is undeniable, and there's data that the optical platform is in decline. It's in my presentation, Nielsen data. There's less penetration of optical disc players in the home. The optical disc is actually no longer in a majority of computers anymore, so they do not play. Microsoft abandoned DVD playback back in Windows 8. So I'm just trying to provide a little bit of balance here to a lot of information that's come out that basically, let's get back. Are we in the same planet?
All right, I think we need to move on because
Okay,
we're out of
I'm
time, but
moving on.
we appreciate that. Thank you.
So thank you. And just briefly, Mr. Williams premised a few of his comments on the notion that physical product is different from digital product. I think that's a direct quote. Every DVD I know is a digital product. So it's sort of, and conversely, there is no digital product that doesn't have a tangible medium of expression. There are no files floating in the ether that one can pull out of thin air and put on something. So, it's a distinction without a difference to say that one thing is delivered on a disk and the other happens to be on a USB or a hard drive or some server farm. There's always a material object somewhere. I did want to correct the statement that each time one stops, the other starts. That's not the way our technology would work. Only the person who owns that copy can watch it, and no one else can watch it until someone else becomes the owner of that copy. So there is no ability for me to end the movie and someone else instantly starts watching it. There has to be a volitional act of returning that copy back so that OmniQ would become the owner, for example, and then passes that on to another customer. Deterioration, I think it was in the 60s, book publishers were talking about deterioration, and the register rejected the notion that you should have extra rights because your book is more durable, and it's now going to be loaned out more often and passed around in secondary markets. That's what Section 109 was all about, and where Congress said we don't want the copyright owner to have any control whatever over the article once you put it out there. There have been efforts by copyright owners in the motion picture studio area that were trying to, at one time, put in counters on VHS tapes so that after a certain number of plays, it would not play anymore. That didn't quite fly. The EZD DVD was a self-destructing DVD. There have been efforts to make the product less durable, but the Copyright Act doesn't recognize any legitimate role to say I should have greater rights because my copy is more durable.
Okay, thank you very much. I appreciate this robust discussion. I think some of this is also reflected in the written comments, or at least would have had the opportunity to have been raised during those. So since we need to set up for the next panel, I think we're going to draw it to a close. So thanks very much. We will come back at 11 o'clock to discuss Class 1, which is audiovisual works, criticism and comment, ebooks, and filmmaking. Thank you.
Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.